Welcome back to the video lecture on ASEAN state practice in the domestic implementation of international law. And at this time, I'm going to give you the general observations in the case of the human rights and trade investment. First, let me touch upon the human rights issues, and specifically civil political rights. In principle, all ASEAN states recognize established rights like free speech and religious freedom. Although the scope and content of these human rights differ as to their practical realization, the lack of respect for religious conscious rights drives the apostasy, blasphemy, and anti-propagation. For example, in relation to death penalty, the debate in Article 2 ISDS terms relate to what and who get to define what a serious crime is. Notably, second, the optional protocol, the ISDS is precisely which is oriented toward the view that there is no absolute international legal prohibition against death penalty, despite there being a very strong international trend against capital punishment. With respect to contested claims like LGBT rights, things are clear in a state of influx. For example, there is no authoritative universal treaty norm prohibiting discrimination on sexual orientation grounds or endorsing same-sex marriage. And ASEAN state practice support the view that there is no customary international law norm in this respect. At best, these claims are de lege ferenda. Let me touch upon the socio-economic rights. In the ASEAN context, a variety of the legal and political methods are adopted to protect and promote socio-economic rights and their underlying welfare considerations. With the proliferation of the BIT in terms of trade and investment issues, and FTAs and regional arrangements in Asia, disputes and in particular ISDS cases involving ASEAN states have grown significantly over the years. The dispute resolution provisions in the BITS in the FTA investment chapters by beyond the state-to-state arbitration and have historically incorporated ISDS provisions. In recent years, at least some ASEAN countries have gone beyond the arbitrations and focused on dispute provisions and dispute prevention through alternative dispute resolution, such as mediation, both state-to-state and investment-to-state. Most ASEAN states are party to the Washington Convention, establishing the International Center for Settlement of Investment Disputes, ICSID, which is the ICSID we are called, and 1965, and New York Convention on the Enforcement of Foreign Arbitral Award, 1956. The ICSID process allows an investor to bring a dispute under the ICSID dispute settlement rules. In case of a finding a violation against the host state of its treaty obligations, the arbitral award can be enforced as if the award is a final judgment of the host state court. BITS and investments characters in open incorporate these mechanisms for settlement of dispute between investor and the host state. However, few ASEAN states such as India, Thailand, Vietnam have been selective in their ratification of the ICSID Convention and have cited reservations. In a recent decade, the several ASEAN states have attempted to go beyond the US-style model, the BITs, and to tweak the rules in the recent BITs and FTA investment chapters. Annex B reflects the currently available model text of the dispute settlement provisions of Asian states. This may be an era worth future study in an event that more ASEAN states negotiated treaties based on different model dispute settlement treaties. ASEAN states' future dispute settlement provisions should also be considered in conjunction with the EU's potential development of an appellate mechanism for investor-state disputes. Vietnam has agreed to the appellate mechanism provisions. It does remain to be seen whether such dispute resolution mechanisms may influence ASEAN states or whether ASEAN state new treaties will reveal an alternative trend. These emerging trends, the consequences of which may be reflected in the ASEAN state practice in decades to come, do not negate the predominant use of ISDS provision in the current BITS. Thus, a second and related potential area of study would be whether ASEAN states will terminate their existing treaties and replace them with something else. India and Indonesia have taken the drastic step toward fundamentally altering their BITs because of the several adverse ISDS claims and moved toward an approach that makes ISDS arbitration the least preferred option. The recently concluded RESAP has excluded the typical ISDS clause altogether, and that the many signatories to the CPTPP have signed agreement to restrict ISDS. ASEAN states in general have cited several reasons for moving away from the ISDS arbitration, including frivolous investor claims, regulatory chill, and the creation of parallel system of adjudication, and concerning regarding the consistency, coherence, and predictability and correctness of arbitral decisions, and the lack of appropriate mechanism to limit such inconsistencies, lack of independence and impartiality of the arbitrators, the erosion of regulatory power on the host states, and non-recognition of public interest. At least two ASEAN states, India and Indonesia, have taken the drastic step of terminating most of their old BITS. While Asian states in general seem to acknowledge the problems and concerns regarding ISDS, they continue to maintain liberal provisions on ISDS in their BITS. In other words, the old BITS model predominantly dominates the BIT's ISDS provisions in practice among ASEAN states. At the same time, there is an underlying trend toward incorporating improved and all the restrictive versions of the ISDS by some of the states in the recent BITs and regional FTAs. Such concrete states' actions to moving away or improve the ISDS is restricted to a limited number of countries. As shown above, the conscious decision towards restriction of the scope of the ISDS investment regime is visible from the practice of, for example, India, Indonesia, and to a certain extent, Vietnam. However, India seems to be the only country to have taken the concrete step toward this shift, which is evident from its model BIT tax and its recently concluded BITS. When one takes the Asia-Pacific region, Australia and New Zealand can also be included in the category of states who prefer to exclude or limit the scope of ISDS in the bilateral and multilateral arrangements. If the trend from the negotiated outcome of the RESAP is any indicator, the older BITs, ISDS may gradually pave the way for a more reformed or the modified versions of ISDS like recent EU initiatives. Lastly, it may become particularly important to study whether Asian states sign and ratify recent multilateral treaties such as the RESAP and the CPTPP, and in time, how these Asian states implement their international economic law obligation domestically. As these ASEAN states are bound by the same obligations under such multilateral agreements, some level of consistency is expected. However, it still remains to be seen if Asian states will implement the provisions of RCEP, CPTPP, and other multilateral treaties in a consistent manner, or whether other trends will emerge. Thank you very much for your very kind attention.